No.
All right, you're excused. Thank you. We'll call the next case, S.A.B. versus R.L.S. Morning, sir.
Morning, Your Honor.
How much time for rebuttal?
4 minutes, please.
All right, sir. Fire away.
Thank you. May it please the court, I'm Andrew Wendell on behalf of the appellant father, and I would like to start in a bit of an unconventional fashion with my argument. There is a unique issue before the court today, which is the motion for appellate attorney's fees. That very issue has been certified as a conflict between the second DCA's case of BK in 2013, and the case of...
We have a case on that point, though, that is against you, right?
Yes, Starkey, which is the fifth
So
DCA.
the panel can't help you with that. We have no authority to overrule a prior panel opinion. You'd have to move for a rehearing en banc on that.
I understand that, Your Honor, but what we're looking at is a separate and distinct issue within that appellate attorney's fees issue, which is not addressed in the Starkey opinion, which is a unique issue before this court, which is the Equal Protection Clause. In Starkey, the express holding of this court was with respect to the statutory construction and the interpretation of Chapter 61. Specifically, the holding was that because Chapter 61 included mirror language to Chapter 742, but that Chapter 742 excluded the appellate attorney's fees language, that was the basis for the determination appellate attorney's fees did not apply in 742. Separate and apart from that
Did the second district hold that that was a violation of equal protection, or did just Judge Aldenburn say that in a concurring opinion?
My understanding, Your Honor, is that that was part and parcel of the actual holding itself, and that what happened with that was that so there were two. The primary basis was the conflict in terms of the statutory construction, Your Honor, and it was the second DCA also noting briefly, and it was in the body of the opinion. I have that in front of me now.
Did your client raise that issue?
Equal protection, yes, Your Honor. A motion for attorney's fees expressly raised the issue of equal protection. And the issue of equal protection in this particular case, because it's about a legitimacy issue, invokes the intermediate standard of scrutiny. That was defined in 1973 by the Supreme Court in the case of Gomez-Perez. That was reaffirmed in the Mills case, another U.S. Supreme Court in 1982, and more recently in the Ramos case, the second district reaffirmed that legitimacy gets intermediate scrutiny.
Your argument is that it's a violation of equal protection for the legislature to confer upon parties in a divorce action entitlement to appellate attorney's fees, but not to give the same right to the parties in a paternity action. Is that your argument?
Very close to that, Your Honor, yes. That the interest of the child is what's being observed in these actions, because in a paternity action what predominantly is at issue is these time-sharing and child support components.
Well, is this an equal protection argument that is advanced on behalf of the child, or is it advanced on behalf of the parents?
Both, Your Honor. It's both would have an equal protection clause argument there.
How is an equal protection clause argument on the issue of attorney's fees, how is that raised on behalf of the child?
The father, because there is nobody else to raise that argument except for the parents to the child.
But the child didn't pay attorney's fees, right?
But those are the financial child resources from which the child has to live, and without the payment of attorney's fees, the child is not in a position where their best interest can be observed by the courts. They would not have access to the courts to make determinations of whether their rights to child support are observed, or whether it is that their rights to have access to their father is observed.
What did the second district rely upon as authority for that proposition?
The second district, and I will quote from the opinion to answer Your Honor, stated
No, I want to know what, I want to know what they relied on as authority for their assertion.
They relied on, they referenced by citation MJI versus AJK, which was 55 Southern 3rd, 732, quoting 733, which was their own particular case that came before, in stating that, and then that's where the concurring opinion that they relied on came from. In the body of this opinion, they weren't relying on concurring opinion. It was the opinion of the majority, and it was all-inclusive of the three judges. But that prior opinion, which I've just cited, is what the concurrence was, which stated that under any level of scrutiny, it is not obvious to me that parents of illegitimate children should be treated differently than parents of legitimate children when it comes to the rules for awarding attorney's fees on appeal in custody disputes.
Now, that was Altenburg's concurrent opinion, though, correct?
Yes, Your Honor, that was the concurrent opinion, which then was given, which then was incorporated into this particular opinion.
I guess I asked the question inartfully. What did Judge Altenburg rely on as authority for his assertion in his concurring opinion?
Other than the Equal Protection Clause itself, Your Honor, I don't know that there was specific other authority given. The Equal Protection Clause, as I filed as a notice.
Well, certainly this must have come up somewhere in someplace. Is there any authority other than Judge Altenburg's opinion on this?
This is actually a very unique issue, Your Honor, because what we have outstanding right now on the paternity issue and the fee awards is simply a case from the 4th DCA, a case from the 2nd DCA, and a case from the 5th DCA. There is very little with respect to the analysis under an Equal Protection Clause, and in my review of those cases that are outstanding now, this case, BK from the 2nd District 2013, is the only one that has addressed this with an Equal Protection Clause analysis. And so what I would suggest to the court is that as a completely independent basis, because the 5th District Court of Appeals has never reviewed this under Equal Protection Clause analysis, that there's an independent basis. And certainly in that situation, there is a distinct and independent basis for not just a reversal of the prior opinion, but rather moving away from it based off of a different grounds that the court was not able to speak to before because it wasn't presented to the court. The court did not have the opportunity to look at that particular issue. And moreover, this Equal Protection Clause issue then interrelates to actually the trial issue.
Did you want to get to the merits of your appeal, or did you want to spend all your oral argument on attorney's fees?
No, Your Honor. I'm moving just briefly to the interrelated issue of the fees at the trial court as well, because underlying the basis for appellate attorney's fees and interrelating to the trial fee award is the fact that then there has to be a distinction between the financial resources of the party. Briefly, to summarize that, the mother's earnings were in excess of 4 times that of the father. There was an income discrepancy of over...
Did the trial judge make a finding as to what the quantum of reasonable fees are?
Yes, it seemed to, there was not an express finding, but the trial court did just directly state that the fees that have been testified to for the father were $31,948.10. And then when adjudicating the fee award at the trial level, making the award of $10,000, the trial judge was explaining that they were leaving that other almost $22,000 on the table, not making a contribution to that. So it was...
Did the trial judge find that $31,000 was a reasonable fee for the services of the father's lawyer?
There was not an express finding to that, but it was incorporated that that was the amount that was expended, and there was no competing evidence with that fact.
But didn't the father withdraw money from the joint accounts for payment of attorney's fees?
Yes, but there was no affirmative claim for affirmative defense of an offset or anything like that, and that those funds were done in such a way that it did not free up his access to actually maintain an attorney itself. And so when we have these particular income issues, then that also parlays into the issue of child support. There was a clear error in calculation of child support in that the trial court's determination that the father made $130,000 less than the mother and less than a quarter of what the mother made was actually not appropriate under the facts of this case. The mother's own financial affidavit, the original, indicated that she earned $15,833 a month. She amended that when she received a raise to earning $16,417 a month. She filed a child support guideline calculation that indicated that same amount from her financial affidavit. Her trial testimony was that she earned $16,417 a month. Yet the trial court used an amount in excess of $2,000 less. And the only reason, and the only thing before the trial court that ever represented the lesser figure,
$2,000 less
over $2,000 less per month.
per month?
Per month. Yes, Your Honor. And in addition to that, the trial court then looked at the father's income, and they never was an argument before the court that the father should be imputed income. And the trial...
The mother's paying for the private school tuition, paying for a nanny, and there was never any objection by the father to the child being in a private school, was there?
No, actually, Your Honor, that's not the case. The mother is not paying that. What the final judgment actually says is that the parties are free to leave the child there, and then the parties may apportion that cost as they see fit if they choose to leave the child there. There was no obligation of the mother to continue enrollment in
Wasn't the evidence that the mother was paying the private tuition?
prior to, but this was a 5-year-old at that time, and so she had not entered yet into those higher level of grades. She had not matriculated to first grade and so on, where it's customary for children oftentimes to have private daycare type educational expenses and then to matriculate into public school at that time. And it was directly contemplated by the court that the father might have some level or all of the level of contribution to that private school. Likewise, the mother herself indicated that she was not looking for reimbursement for the nanny, and the trial court expressly found that the nanny was not falling within the confines of reasonable daycare provider. So,
but this was a very volatile divorce, and this nanny had been with this child for really since the child's birth. Isn't it in the best interest of the child to maintain some consistency in the child's life when the parents are going through such a volatile...
And certainly that's not disagreeable at all, and what the trial court could have and should have done is, because daycare is a statutorily mandated component of child support, the trial court could have included a reasonable daycare expense with respect to the nanny, but chose not to, and instead simply zeroed out child support. It wasn't as if there was some sort of mathematical analysis or even a reliance on 61.13's deviation standards.
Now, the mother has the primary, more time sharing, significantly more time sharing than the father, and it's just the disparity of income that led the father to be entitled to some child support, correct?
The disparity in income, and while the mother, the problem with the recurring time-sharing schedule is that the father, while he's afforded more time in the holidays and the summers, his recurring time-sharing schedule is such that he gets less than 72 hours every 2 weeks. He doesn't even get a full weekend.
That's an abuse of discretion under the circumstances of this case, given all of the evidence before the trial court?
Yes, because the court expressly found that the dad loves the child. The dad has a disposition to encourage a close and continuing parent-child relationship. He genuinely wants to be more involved. He feels the mom is shutting him out. The mom's conduct has been inappropriate, that the mom relies on a nanny, that the parties live close, that the dad has been involved in the child's school and extracurriculars, that the dad demonstrates that he can meet the child's needs. Those were express findings of the trial court in pages...
He also found that the dad acted inappropriately.
He did, Your Honor, yes. Both parties acted inappropriately. I don't think that there's any...
The dad had admitted to smoking hashish, had some substance abuse accusations and issues.
I'm glad that Your Honor brings that up, because the only allegation about the hashish was that overseas, away from the child, that there was that issue. The father, the trial court...
Didn't the mother have pictures of paraphernalia in the garage of the husbands?
The mother did present those issues, but what the trial court found on that issue is that there was never any interrelation between the substance abuse allegations and the child. Further, what was testified to by the mother's own expert is that the father does not have a substance abuse, does not meet the criteria for substance abuse issues. The father's expert said the same thing. The father's counselor said the same thing. The father was breathalyzed before each and every visit with the mother observing it and never passed the agreed upon threshold for a breathalyzer. The father was also roommates with a doctor who specialized at the Orlando VA in substance abuse. He lived with that person, and that person attested in court and under oath that he had never seen any issues with the father consuming any illicit substance or alcohol, and that the father did not appear to have a substance abuse issue. The substance abuse issue has been a big red herring in this case, and it's completely unfounded to the point that even the trial judge found that there had never...
Completely unfounded. I don't know, I am not sure, completely unfounded. He's acknowledged, they had pictures of alcohol bottles in the garage, and where he's been apparently squirreling away these bottles, and he had paraphernalia in the garage. He's admitted to, smoking hashish. He's admitted at the time that he was undergoing counseling that he had consumed some alcohol while he was, doing the, the analysis or the evaluations. How is that completely unfounded?
Well, the issue is that there's never been a correlation between those allegations and the father's parenting. The hashish, again, was overseas. It was out of the country. The child was not present. The father wasn't even in the country. With respect to the alcohol consumption, there's all of these experts, including the mother's experts, who have attested that he does not have a substance abuse issue, and the child judge himself found that there was never a correlation between any sort of substance abuse substance abuse allegation and the child and his ability to engage in child rearing. And that is what I rely on, Your Honor, to indicate that while all of these things were raised and that was the focal point of the mother's focal point of the mother's argument, the time sharing that's been acted here, where the father doesn't even have a full weekend. His weekend starts at 5 p.m. on a Saturday, where the father has to elect in advance that he's going to exercise his weekend contact, where there's 11 full 24-hour periods that pass between each of the father's visits with
There
his...
were also some domestic violence issues that the trial court considered, were there not? And aren't those valid considerations?
There was an allegation of domestic violence at the onset of the proceedings. The parties lived together as a family unit and separated, and at the time of separation, the mother did make an allegation of domestic violence.
Did the trial judge make a finding of domestic violence?
There was, I don't believe that there was ever a finding that there was violence that affected the child. I do believe that there was an acknowledgement that there had been, because the father stipulated to the domestic violence, and part of that was to attend substance abuse counseling. He voluntarily agreed to do that, voluntarily agreed to the breathalyzer test to demonstrate his own sobriety since that was being brought forth. And this was a case that spanned roughly 2 years, and over that time complied with his obligations and had no issue with getting substance abuse counseling, had no issue with getting these breathalyzers completed to demonstrate that he was not intoxicated or inebriated when contacting the child. And so what I point the court to...
He had a .008 one time, right?
I don't believe it was quite that high, but there was one positive blow that did not...
.008 is not that high.
It was a...
Close.
Oh, I'm sorry. Then yes, I apologize. And it did not meet the agreed upon... There was one out of 2 years, one positive blow, which did not meet the agreed upon threshold for the parties, in that it was a very de minimis blow that could have been triggered by something clearly different than drinking. And so because that never became an issue, we don't have facts around that about why that blow was that way, because of the fact that the father had not met that threshold. But what I point this court to is that the Collins case out of this court in 1999 involved 2 children, one of which was 5 years old, and it was found that this sort of every other weekend contact was too infrequent. In this particular proceeding, we have a situation where the father is marginalized to less than 72 hours every 2 weeks of time, and that then we get into this issue of shared parental responsibility, which is really just disguised sole parental responsibility, because the mother was given every single ultimate decision-making authority conceptually possible, with the exception that the dad gets to choose extracurriculars on his own time.
I want to go back briefly, since you started with attorney's fees, maybe we'll end with it, but there was a $7,500 withdrawal fund or charge on a credit card, and then there was a $3,880 withdrawal, a $5,000 withdrawal from money market accounts. $12,655 out of two Regents accounts, $400 out of a checking account, and on my math, that's a little over $28,000. Is there a dispute that the father got those funds?
The dispute, I think,
Or yes or no? Did he get those monies?
it's not a dispute that he got those money, it's the source of the monies, that's at issue. So to be clear with Your Honor, no, it's not a dispute that he got those monies, but the problem with that is that they've commingled their funds because they were living as a family unit. So his contribution of funds and her contribution of funds.
So there's a joint account, and he takes out $28,000 approximately, or
These are accounts, yes, that he had access to as well.
no one's claiming that he didn't have access to it.
Yes.
But he received, he took out that $28,000.
Yes, over the course of time, but again, that's, if he's contributing to the household expenses as well, to not take out any
Those
funds.
weren't used for household expenses, those were used for fees and other personal expenses.
Well, for his own life needs, because that's where his funds was into these
Defense
accounts.
Lawyers paying,
Well, partially, but without any contribution to that, there would have been no ability for the father to eat or to put gas in his car or to pay his car payment or anything like that, because the father was in a situation where he was also contributing his income to the household.
Right.
Okay,
All
thank
right,
you.
you don't have much time left for rebuttal. You want to save it?
Yes, Your Honor, I believe so.
All right,
Thank you.
great.
May it please the court?
Could I get you to begin by addressing the discrepancy in income between the mother's affidavit and the finding in the final judgment? You don't seem to address that in your brief.
I will do my best, Your Honor. First of all, let me introduce myself, Mercedes Wexler. I have the honor of representing R.L.S. in this case, who happens to be in the audience. In terms of the $2,000 differential, I don't have an answer for that. I can only surmise that the judge used a net income amount, but as opposed to a gross for her, and it was
We
simply.
need to send it back and let him take another look at that, right?
I'm sorry?
Don't we need to remand it to let the judge reevaluate?
My argument on that point would be it's harmless error, because at the end of the day, my client is paying all of the expenses for the child anyway. So as she has.
Go ahead, explain what you mean by that.
Well, even though Mr. Wendell came here and argued that the father was contributing to the household expenses, indeed he was not, and that was not the evidence. The house that was in which the parties lived was in my client's name. She purchased it, she paid for all of the expenses, she paid for the school. It's a Montessori school, it was not a daycare, it is a school, a Montessori school, and she was paying.
Subsequent to final judgment, what is the economic distribution in terms of responsibility for private school if the child is indeed in private school?
As I read the final judgment, it's 100% on my client's coming out of her wallet. She's been always the one that she pays all of the gymnastics, all of the extracurricular activities. She receives no contribution whatsoever from the father.
The decision to put the child into a private school is her decision.
It was not, and in fact, the testimony.
The parties agreed, but on a go-forward basis, it's her decision to do that.
She has the ultimate decision, meaning that she must confer with the father, and they have to attempt to agree, and if they cannot agree, then she ultimately makes the decision, and she ultimately will be paying the cost of that private school as well.
Based upon her decision.
Based upon her decision after conferring with the father on that point.
The same thing with the nanny. I mean, it's her decision to keep the nanny.
If that were the case, yes, and as I can't remember which judge, it might have been Your Honor.
We all look alike.
You all look alike. No. The nanny had been a part of this child's life virtually, not since birth, but since she was 1 year old. And the father was instrumental in choosing the nanny. He interviewed the nanny, and the nanny was in the home while the father was supposedly working from home. So he was present in the home during the whole time leading up to this litigation, he wasn't caring for the child, the nanny was caring for the child. And the nanny's testimony was that he was uninvolved and did everything he could to avoid interaction with the child, including drinking himself to oblivion almost on a daily basis. May I proceed with the, very briefly on Mr. Wendell's argument regarding appellate attorney's fees. I went back and I looked at the legislative history of both statutes. And what is interesting to find is that both 61.16 and 742.045 track every revision tracks until you get to 1994. In fact, the revisions are contained in the very same bill. When you get to 1994, this 6116 was amended to add the words "and appeals." 742.045 was not. And every amendment after 1994, also both statutes tracked exactly, often contained in the same bill. I think that the reason for that is clear. The paternity cases are different to divorce cases. Paternity cases necessarily involve time sharing, parental responsibility, and the financial component of child support. Divorce cases have all kinds of other issues, including alimony and equitable distribution as part of it, and those kinds of things, as well as possibly, if there are children involved, time sharing and child support. So I think that that's the essence of the reason for the difference between the two statutes. That there's not a state interest here, there's not a governmental interest here. Somebody who is arguing, as the father is here, that the judge somehow made a mistake and abused his discretion in ordering the time-sharing schedule that he did, he already got the benefit. My client had to pay $10,000 in addition to the almost $28,000 that the father took out of the accounts or charged on the credit cards, for which he never paid a dime. So he shouldn't then be able to still get money from the mother for arguing over what he perceives as an abuse of discretion with respect to time sharing.
How long a marriage was this?
They were never married.
All right, so paternity, all right,
Yes,
you're right.
they were never married.
I knew that.
Yes. So, in this case, the $10,000 was a tough pill to swallow for the mother, especially after the father already took $28,000. The $7,500 that was on the credit cards, $3,500 of it was for the father's criminal attorney, for his arrest for domestic battery against the mother. He never reimbursed her for that money. My client is making the payments on that credit card. He drained their joint accounts, and he was driving a car that was registered and paid for by my client, and the insurance was paid for. He had everything was covered for him. He didn't have to contribute anything other than to be a good father, and he wasn't able to do that. In this case, in terms of the time sharing and the ultimate decision making, the evidence was overwhelming. Your Honor is correct. It's not only that the father's conduct was inappropriate, it was legally inappropriate. The court found that and wrote that into the final judgment. He was unable to moderate his behavior at any time without any regard to how that behavior affected this child. He did it in the presence of anybody who would watch. There were videos presented to the court and audio tapes presented to the court in which he was abusive, harassing, he used profanity, he urinated in the mother's yard in the presence of the child, he did profane gestures to the mother, to the nanny, in front of the child, in front of the parents at the gymnastics facility. He showed up at the gymnastics facility and was trespassed. The deputy who testified said she smelled alcohol on his breath, all while he was in substance abuse counseling, all while he was doing his minimum 8 sessions with the alcohol addictions person. The time that he admitted to smoking hashish, there's nothing in the record that said he smoked it overseas or anything like that. He simply admitted to the substance abuse evaluator that he could not pass a drug test at that point in time because he had smoked hashish. He did not voluntarily submit to the substance abuse evaluation until after the mother filed a motion requiring him to do that, and it was called up for hearing. And curiously, the report, Ms. Wright's report, is dated 4 days after the agreed order on the substance abuse evaluation was entered. He did not do that until he was pressured to do that. In terms of the breathalyzer, that was a voluntary agreement. He agreed to use the breathalyzer as a condition of seeing this child. He was coming to the house, and he was seeing the child, and he was blowing into the breathalyzer. Even in the final judgment, the court found that he could not, but what he did was he made fun of the breathalyzer, and he made a show of it in front of the child, and he argued with the mother or the nanny, whoever was administering the breathalyzer. In terms of that .008, the argument that it didn't come to the agreed upon threshold, he argued about a third digit. And what he did was in the next visit, he put a piece of tape over that that third digit. He covered up on the breathalyzer machine, and he said, "We only agreed to go out 2 decimal points, not 3 decimal points." There's nothing like that is in the agreed order on the domestic violence.
How do you justify your clients allowing the child to be present when he took breath tests?
The child was in the home. The child was preschool age. She was running around the house.
The findings that the trial court made.
Unfortunately, I don't agree with that.
Well, there's no appeal on those findings.
I understand that.
So you're bound by them, and we're bound by them.
Correct.
So how?
This is, at that time, a 4-year-old, almost a 5-year-old child. She's running around the house. And there were times when the father would say, "Sophie, call her over, show her the results," or say, make fun of it. And they tried to have the evidence was that they tried to have the administering of the breathalyzer out on the front porch, so to shield the child from that. He insisted on walking in. He would walk in, he would come in, he would go to the bathroom, then he'd come back, and then he would agree to do the test. There were all kinds of little delays that he would do to cause, when it came time for him to leave, instead of saying goodbye to her, this was all in the transcript, saying goodbye to her, not making a big issue out of it, he would make a big issue out of it. He'd say, "Mommy's making me leave now." These are the kinds of things, this is the kind of legally inappropriate behavior this father did, and he did it in the presence of anybody.
Well, the trial court didn't think that your client was doing a terrific job of allowing him to maintain a relationship with the child either.
Your question is that...
Well, you're complaining about all these actions of him, but apparently this is a two-way street.
I think that the trial court understood the dynamics of this relationship over the long period of time, because I do recall, and it's in the transcript, the trial judge specifically asking the mother, "Why did you let him come from Texas to Florida?" And, the mother testified that she felt that she was trying to keep her family together. She felt that it was probably best. She didn't want to upset the child at that time. She thought at that point in time, she really didn't feel that she had a choice.
Explain again your harmless error on this $2,000 math error.
Well, one, I think that it's, without any basis whatsoever, admittedly, I think that the trial court was using that as a net income figure as opposed to a gross. But I do think that it's harmless because at the end of the day...
What was the net income figure that was shown on her financial affidavit?
I don't have that in front of me. I don't have that in front of me. I apologize. If she makes $16,000 a month, I would guess that a net income might be $2,000 to $3,000 less per month.
Didn't he get some child support, though, at the end of the day here?
He did not. He was not awarded child support. The court found that it was so nominal, and given that she was paying all of the other expenses, that the court declined to award child support. And the case is actually, in particular, if you look at Finley v. Scott, which is the Florida Supreme Court case, it talks about a trial judge has the discretion to make sure that the child's needs are met. And in this case, they were met. They are being met, as they always have been met by the
If the
mother.
trial judge used the right income figure, might not he have awarded some child support to the father?
I think that he acknowledged in that, if you look at the child support guidelines, it says it's about a $200 amount going from the mother to the father, but he did not award that because he said the mother was paying all of the child's
But if
expenses.
he used the right income figures, that
It would probably change some, yes, it would.
Right.
If it depend, I don't know whether it was a net or
Shouldn't we
gross.
give the trial judge another?
Again, I don't think it makes a difference at the end of the day because my client is going to be the one paying it anyway. She pays it all now anyway. She was even ordered to pay the Our Family Wizard cost, which is the electronic service that allows them to communicate and handle parenting issues, and she is required to bear even that cost. So, in terms of the time sharing, one of the arguments that the father made was it was important for him to have frequency of contact, not necessarily overnight. He gets frequency of contact. He sees this child almost on a daily basis. The reason that his weekend doesn't start until Saturday at 5 is because he's working on Saturday mornings. He testified to that. So his weekend was extended to Tuesday morning. So he's not losing any overnight time. It's his choice to do what he does, which is this medieval sword fighting training, and he trains on Saturday mornings. That was his testimony. So the judge was simply accommodating his work schedule. He has approximately a 35% schedule. That's a lot of time. That's substantial time under the statute. He wanted 50-50. The judge found that would be not in the child's best interest, but he got a lot of time for this child. In terms of the ultimate decision-making, again, I go back to the father's behavior and the level of hostility, and all of the cases that I cited say that when there is such a level of hostility between the parents, somebody has to make the ultimate decision. Because taking these issues such as gymnastics or medical decisions or that, every time they have a disagreement, and I can safely say in this case, there will always be a disagreement, you have to go to the court. That means filing a motion, that means maybe doing some discovery, and that means setting it for hearing, and you're looking months down the road. And as the trial judge observed in this case, sometimes the status quo is to the detriment of the child. The trial judge used the example of braces. If the child needs braces, and one parent agrees and one parent doesn't agree, and you take it to the court to argue about it, you're looking at 6 months to a year down the road before any decision is made about whether the child gets braces. In the meantime, it's to the detriment of the child. In terms of the witness that Mr. Windle talked about, that testified, the doctor who was with the VA, he was a personal friend of the father. There was testimony that he trained with the father and that he'd known the father for years. So I would take that testimony with a grain of salt, only because...
Isn't it no pun intended, but that's a two-edged sword here. I mean, either you present people that know you well who can testify to it. What's your alternative? To testify, to bring in people who don't know you well?
Well, but I believe Mr. Windle was offering him as a quasi-expert in terms of whether the father had a substance abuse problem. Dr. Dean was never qualified as an expert in substance abuse. He never treated the father. He never evaluated the father. The father simply rented a couple of rooms from him after he was removed from the home, and and they had a personal relationship. He took sword fighting lessons from the father, and their children interacted. So he was never...
Yeah, your client works for WFTV, is that right?
She works for WESH.
WESH, that's
Yes.
exactly. If she worked for FTV, she could explain to George Estevez that SWORD is not sword.
Perhaps she can
Yeah.
send a little quiet
I don't
email
think
over
it works
to the
that way.
competitors.
I don't think it works that way.
Your Honors, if you have any other questions?
Nope, thank you.
Thank you very much.
All right. And you've got 24 seconds. I'm going to hold you to it. Counsel didn't use all of her time, so.
Hop to it, Your Honor. Page 7 of the parenting plan refers to the elective time that the father might also be entitled to. On that particular provision, it's subordinate to the mother's right to put the child in extracurricular activities instead. So the father does not have a right to see the child more frequently. It is only an option of the mother to choose between the father or extracurriculars. Thank you.
All right, thank you. Thank you for your arguments. Court will be in recess.